Okay, so magandang gabi sa inyong lahat. At nandito na naman ang inyong Lolo Ray para magbasa-basa na naman ng batas, no? Actually, yung binabasa natin ngayon is tungkol muna sa mercantile law o yung commercial law. At ang sisimula naman natin ngayon ay ang insurance, no? Ako nahanap sa mga pagtitingin-tingin ko na magandang basahin. Nahanap ko yung Insurance Act. Although nakikita ko na yung insurance code ilang beses nang naamyendahan, etc. etc. Pero itong Insurance Act number, yung Act number 2427, parang nakita ko na komprehensibo siya. At sa tingin ko, maaring may mga pagbabago na po. Yun nga, naamyendahan na batas. Pero sa pananaw ko, dito natin mauunawaan pag binasa natin to, yung mga konsepto ng insurance, di ba? Okay, magsimula na tayo. Yung section 1 niya, sabi lang naman, the short title of this act shall be the Insurance Act. Magtungo naman tayo sa chapter 1, Insurance in General. Sabi rito sa section 2, no? Insurance is a contract whereby one undertakes for a consideration to indemnify another against loss, damage, or liability arising from an unknown or contingent event. Okay? So, ang insurance daw ay isang uri ng kontrata kung saan yung insurance company, undertakes for a consideration to indemnify another against loss, damage, or liability arising from an unknown or contingent event. Pero yung dahil luma ito, siguro pwede kong dagdagan to upon payment of the premium. Siguro ganun, ano? So, sabi rito, what may be insured? Section 3, any contingent or an unknown event, whether past or future, which may damnify a person having an insurable interest or create a liability against him, may be insured against subject to the provisions of this chapter. So, yung mga contingent or unknown na event, whether past or future, no, na maaaring makasira sa tao, no. Section 4, the preceding section does not authorize an insurance for or against the drawing of any lottery or for or against any chance or ticket in a lottery drawing a prize. Okay. Siyempre, game of chance yun. Laro yun eh. So, okay. Section 5, all kinds of insurance are subject to the provisions of this chapter so far as the provisions can apply. Okay. Basa-basa lang tayo para maintindihan lang natin ang konsepto ng insurance. Parties to the contract, Section 6. The person who undertakes to indemnify another by a contract of insurance is called the insurer, and the person indemnified is called the insured. Section 7, every person, company, corporation, or association who holds a certificate of authority from the insurance commissioner as elsewhere provided in this act may be an insurer. Okay, so hindi ko alam kung yun pa rin ang tawag, kung yung certificate of authority pa rin from the insurance commissioner, no? Basically, kung nabago man yung term, yan, iisa pa rin naman yung sense, no? Section 8, anyone except a public enemy may be insured, okay? Section 9, unless the policy otherwise provides, where a mortgagor or property effects insurance in his own name, providing that the loss shall be payable to the mortgagee, or assigns a policy of insurance to a mortgagee, the insurance is deemed to be upon the interest of the mortgagor, who does not cease to be a party to the original contract, and any act of his prior to the loss which would otherwise avoid the insurance will have the same effect although the property is in the hands of the mortgagee, but any act which under the contract of insurance is to be performed by the mortgagor may be performed by the mortgagee therein named with the same effect as if it had been performed by the mortgager. Okay. Sabi lamang dito, yung isang nagsanla daw, yung mortgagor, uh, effects insurance in his own name providing that the loss shall be payable to the mortgagee. Okay. Or assigns a policy of insurance to a mortgagee. Yung insurance daw is deemed to be upon the interest of the mortgagor. Okay? Okay. Kahit na yung ari-arian daw ay nasa kamay nung pinagsanlaan. But any act which under the contract of insurance is to be performed by the mortgagor ay pwedeng gawin ng mortgagee. Okay? With the same effect as if it had been performed by the mortgagor. Okay. Section 10, if an insurer assents to the transfer of an insurance from a mortgagor o pumayag siya, pumayag yung insurance company, pumayag yung insurer na i-transfer to the transfer of an insurance from a mortgagor sa nagsanla to a mortgagee sa pinagsanlaan, and at the time of his assent imposes further obligations on the assignee making a new contract with him, the acts of the mortgagor cannot affect the rights of said assignee. Okay? Okay, ito magandang topic itong basa-basahin. Insurable interest. Section 11, every person has an insurable interest in the life and health of letter A, of himself, letter B, of any person on whom he depends, wholly or in part for education or support, letter C, of any person under a legal obligation to him for the payment of money or respecting property or services of which death or illness might delay or prevent the performance, and letter D, of any person upon whose life any estate or interest vested in him depends. So yun daw, so meron tayong insurable interest syempre sa ating sariling buhay, sa isang tao na nakadepende tayo, whether in part or wholly, usually mga magulang natin yan, or any person daw na may legal na obligation sa atin. Okay, merong utang sa atin yan. At saka any person daw na whose life, any estate or interest vested in him depends. Okay, so pwede nating i-insure yung sarili natin at yung mga taong nabanggit dito. Okay. Section 12, every interest in property, whether real or personal, or any relation thereto or liability in respect thereof, of such a nature that a contemplated peril might directly damnify the insured, is an insurable interest. Okay? Okay, so habang binabasa naman natin to, unti-unti nating nauunawaan naman yung insurable interest, no? Pero subukan kong hanapin lang, i-google natin, i-define natin yung eksaktong ibig. Alam ko gets nyo naman na, pero ibig sabihin ng insurable interest. Sabi rito, insurable interest is a type of investment that protects anything subject to a financial loss. A person or entity has an insurable interest in an item, event, or action when the damage or loss of the object would cause a financial loss or other hardships. To have insurable interest, a person or entity would take out an insurance policy protecting the person, item, or event in question. The insurance policy would mitigate the risk of loss if something happens to the asset, like becoming damaged or lost. Okay, no? So kaya doon natin maiintindihan yung mga news na kunwari yung isang professional baseball player in-insure niya yung kanyang throwing na kamay. Kunwari kaliwete siya or kanan siya, yung kanang kamay niya na pang pitch ay in-insure niya kasi damage to that will cause significant loss financially sa kanya, no? O magtungo na tayo, Section 13. An insurable interest in property may consist in letter A, an existing interest, letter B, an inchoate interest founded on an existing interest, or letter C, an expectancy coupled with an existing interest in that out of which the expectancy arises. Okay, so tignan lang natin ibig sabihin ng inchoate. Yan ang hirap sa batas, no? Sobrang daming mga salitang hindi maintindihan. Okay, ibig sabihin ng inchoate ay anticipating or preparatory. Okay, inchoate interest founded on an existing interest. Yun ang ibig sabihin dito eh. Or ibig sabihin just begun and so not fully formed or developed. Okay. Hindi pa lubos na nabubuo, okay? Okay, Section 14, a carrier or depository of any kind has an insurable interest in a thing held by him as such to the extent of his liability but not to exceed the value thereof. Section 15, a mere contingent or expectant interest in anything not founded on an actual right to the thing, nor upon any valid contract for it is not insurable. Kasi contingent or expectant interest lamang siya eh. Hindi siya founded on an actual right. Hindi kagaya ng insurable interest natin sa magulang natin na kung saan yung insurable interest is on the actual thing, on the actual person eh. Mga magulang natin na nagpapakain sa atin eh. Itong sinasabi sa Section 15, mere contingent or expectant interest in anything not founded on an actual right to the thing nor upon any valid contract for. Wala naman kayong usapan o wala ka namang karapatan sa isang bagay, eh hindi mo pwedeng i-insure. Ano namang kinalaman mo ron? Wala ka namang insurable interest doon. Sabi nga. Section 16, the measure of an insurable interest in property is the extent to which the insured might be damnified by loss or injury thereof. So, pwede mo sigurong i-insure yung isang heavy equipment mo na ginagamit mo sa hanap buhay, di ba? Na kapag yun ay nasira, eh talagang damnified ka. Damnified yung isang tao. So, damnified. Ano ibig sabihin ng damnified? Pagkakaintindi ko rito, parang feeling na na-condemn ka. So, hanapin natin. To cause loss or damage to. Ayan. Damnified. Okay, Section 17. The sole object of insurance is the indemnity of the insured. And if he has no insurable interest, the contract is void. Okay. Yun kasi ang tinitignan eh. Meron bang insurable interest ka? Ano bang pake mo dito? Alam mo yun? Ano ba yung interest? Ano ba yung meron siya na dapat mo siyang i-insure? Di ba? Anong kinalaman mo dun? Ang saktong term is, ano yung insurable interest mo sa kanya? So, yun yung pinag-aaralan ng mga insurance company bago nila aprobahan ng isang policy. Section 18. Okay. Section 17 muna tayo. The sole object of insurance is the indemnity of the insured, and if he has no insurable interest, the contract is void. Section 18, an interest insured must exist when the insurance takes effect and when the loss occurs but need not exist in the meantime. Section 19, except in the cases specified in the next 4 sections and in the cases of life, accident, and health insurance, a change of interest in any part of a thing insured, unaccompanied by a corresponding change of interest in the insurance, suspends the insurance to an equivalent extent until the interest in the thing and the interest in the insurance are vested in the same person. Section 20, a change of interest in a thing insured after the occurrence of an injury which results in a loss does not affect the right of the insured to indemnify for the loss. Section 21, a change of interest daw in one or more of several distinct things separately insured by one policy does not avoid the insurance as to others. Okay. Balikan natin yung 20. Ang sabi niya, ang change of interest in a thing insured after the occurrence of an injury which results in a loss does not affect the right of the insured to indemnify for the loss. So siguro ang example na may isip ko dito, kunwari meron kang heavy equipment na ginagamit mo sa kabuhayan. Tapos nasira ito. Nung nasira ito, may bago ng uri ng equipment na mas mapapadali yung hanap buhay mo. So maaaring nag-change ka na ng interest doon sa thing na insured. Pero hindi ibig sabihin na hindi mo naman na talaga yun ang pinakakailangan mo. Kaso nangyari muna yung loss. 'Di ba? Nangyari mo na yung injury doon sa thing na yun bago ka nakakuha ng isang equipment na mas maganda. Hindi naaapektuhan nun yung karapatan mo to indemnify for the loss. Okay? Okay. Section 22 na tayo. A change of interest by will or succession on the death of the insured does not avoid an insurance, and his interest in the insurance passes to the person taking his interest in the thing insured. So siguro yung nagmana, kunwari may minana na heavy equipment na naka-insured, siya ang nagmana, napapasa sa kanya yung interest dun sa heavy equipment nung insured. Okay? Section 23, a transfer of interest by one of several partners, joint owners, or owners in common who are jointly insured to the others does not avoid an insurance, even though it has been agreed that the insurance shall cease upon an alienation of the thing insured. Section 24, every stipulation in a policy of insurance for the payment of loss, whether the person insured has or has not any interest in the subject matter of the insurance except in the cases provided for in Section 166, or that the policy shall be received as proof of such interest, and every policy executed by way of gaming or wagering, yan, pupustahan, yan, is void. Bawal daw yun. Tignan naman natin yung concealment and representations. Section 25. A neglect to communicate that which a party knows and ought to communicate is called a concealment. Pero kang tinatago. Hindi mo pwedeng itago sa insurance yun. Section 26. A concealment, whether intentional or unintentional, entitles the injured party to rescind a contract of insurance. Ang usually nagtatago dyan, yung mga insured, yung mga nagpapa-insure. Pero may cases din na yung insurance company ang may tinatago, no? Section 27, each party to a contract of insurance must communicate to the other in good faith all facts within his knowledge which are material o mahalaga to the contract and which the other has not the means of ascertaining and as to which he makes no warranty. Section 28, unintentional and fraudulent omission. Meron kang hindi sinabi on the part of one insured to communicate information of matters proving or tending to prove the falsity of a warranty entitles the insurer to rescind. Oo, magkakaroon ng karapatan yung insurance company o yung insurer na i-rescind. Okay? Kasi may fraudulent omission kayo. Section 29, neither party to a contract of insurance is bound to communicate information of the matters following except in answer to the inquiries of the other. Letter A, those which the other knows. Letter B, those which in the exercise of ordinary care the other ought to know and of which the former has no reason to suppose him ignorant. Letter C, those of which the other waives communication. Letter D, those which prove or tend to prove the existence of a risk excluded by a warranty and which are not otherwise material. And letter E, those which relate to a risk accepted from the policy and which are not otherwise material. So, isang mabibigay ko lang na halimbawa yan. May cancer ka. na kukuha ka ng life insurance, kailangan mo sabihin na may cancer ka. Okay. Ibang usapan yung kumuha ka ng life insurance, hindi mo naman alam na may cancer ka, tapos biglang malalaman mo na lang stage 4 ka na. Ibang usapan yun kasi hindi mo tinago wala kang alam. Pero yung matagal ka nang nagme-medication for cancer, tapos kumuha ka ng life insurance, hindi mo sinabi, material fact yun Di ba? Pwedeng i-rescind ng insurance yung kontrata ninyo. Section 30, materiality is to be determined not by the event but solely by the probable and reasonable influence of the facts upon the party to whom the communication is due in forming his estimate of the disadvantages of the proposed contract or in making his inquiries. Section 31, each party to a contract of insurance is bound to know all the general causes which are open to his inquiry equally with that of the other and which may affect either the political or material perils contemplated and all general usages of trade. Section 32. The right to information of material facts may be waived either by the terms of insurance or by neglect to make inquiries as to such facts where they are distinctly implied in other facts of which information is communicated. Sabi rito, yung right, yung karapatan para sa kaalaman ng mga seryosong facts, no? Yung mga relevant na facts, pwede raw i-waive yun either by the terms of insurance or by neglect to make inquiries, hindi ka nagtanong, as to such facts where they are distinctly implied in other facts of which information is communicated. So kapag kaya mga insurance company, sigurado nagtatanong ng matindi yan. Nagre-research yan about your background, kung may sakit ka ba, ikaw ba ay pasaway, ikaw ba ay matkaskasero, may mga kaso ka ba? Titignan nila yan. Section 33, information of the nature or amount of the interest of one insured need not be communicated unless in answer to an inquiry except as prescribed by Section 49. Section 34, neither party to a contract of insurance is bound to communicate, even upon inquiry, information of his own judgment upon the matters in question. Section 35, a representation may be oral or written. Section 36, a representation may be made at the same time with issuing the policy or before it. Section 37, the language of a representation is to be interpreted by the same rules as the language of contracts in general. Kasi kontrata rin naman ng insurance. Section 38, a representation as to the future is to be deemed a promise unless it appears that it was merely a statement of belief or expectation. Section 39, a representation cannot be allowed to qualify an express provision in a contract of insurance, but it may qualify an implied warranty. Section 40, a representation must be presumed to refer to the date on which the contract goes into effect. Section 42, when a person insured has no special knowledge of a fact, he may nevertheless repeat information which he has upon the subject and which he believes to be true, with the explanation that he does so on the information of others, or he may submit the information in its full extent to the insurer. And in neither case is he responsible for its truth unless it proceeds from an agent of the insured whose duty it is to give the intelligence. Section 43, a representation is to be deemed false when the facts fail to correspond with its assertions or stipulations. Okay. So ipagpapalagay na false ang iyong representation kapag yung facts fail to correspond with its assertions or stipulations. Section 44, if a representation is false in a material point, whether affirmative or promissory, the injured party is entitled to rescind the contract from the time when the representation becomes false. Section 45, the materiality of a representation is determined by the same rules as the materiality of a concealment. Okay. Section 46, the provisions of sections 25 to 47, inclusive of this chapter, apply as well to a modification of a contract of insurance as to its original formation. Section 47, whenever a right to rescind a contract of insurance is given to the insurer by any provision of this chapter, such right must be exercised previous to the commencement of an action on the contract. Okay, so ang sinasabi niya rito ha, whenever daw yung karapatan to rescind o to revoke o ipawalang bisa o bawiin yung bisa ng isang kontrata ng insurance, the contract of insurance ay ibinigay sa insurer ng kahit na anumang provision ng chapter na ito, itong karapatan na to must be exercised previous to the commencement, bago mangyari, bago yung pangyayari ng isang, bago yung pagpapatuloy ng isang pangyayari doon sa kontrata. Hirap Tagalogin, no? Pero dapat yung batas natin Tagalog para maiintindihan ng ordinaryong tao paano naman. Hirap na hirap ako. Okay, the policy, section 48. The written instrument in which a contract of insurance is set forth is called a policy of insurance. Insurance policy. Yan. Section 49, a policy of insurance must specify, letter A, the parties between whom the contract is made. Kunwari ako, Lolo Ray and the Chorva Insurance. Letter B, the amount to be insured except in cases of open or running policies. Okay? Letter C, the rate of premium. Magkano ba yung, kumbaga, ito yung premium amount. Kumbaga, ito yung unang hulog. Kumbaga, parang principal amount. Yun. Letter D, the property or life insured. Letter E, the interest of the insured in property insured if he is not the absolute owner thereof. Letter F, the risks insured against. Ano ba yan? Saan mo ba in-insure yung kotse mo? Sunog, pagkabangga, calamity, yung tambangan ka, pagbabarili yung kotse mo. And letter G, the period during which the insurance is to continue. Section 50, the insurance shall be applied exclusively to the proper interest of the person in whose name it is made unless otherwise specified in the policy. Section 51, when an insurance is made by an agent or trustee, the fact that his principal or beneficiary is the person really insured may be indicated by describing him as agent or trustee or by other general words in the policy. Section 52, to render an insurance effected by one partner or part owner applicable to the interest of his co-partners or of other part owners, it is necessary that the terms of the policy should be such as are applicable to the joint or common interest. Section 53, when the description of the insured in a policy is so general that it may comprehend any person or any class of persons, he only can claim the benefit of the policy who can show that it was intended to include him. Okay. Section 54, a policy may be so framed that it will inure to the benefit of whomsoever during the continuance of the risk may become the owner of the interest insured. Okay. Pagkakaintindi ko sa inure ay yung tae ng kalabaw Kailangan hanapin natin. Inure, mapupunta. Parang ganun. Accustomed to something, no? Take effect. Yun ay ibig sabihin. So, ulitin natin. A policy may be so framed, okay, pwede siyang ibalangkas that it will inure, o ang ibig sabihin nun, it will take effect to the benefit of whomsoever during the continuance of the risk may become the owner of the interest insured. Section 55, the mere transfer of a thing insured does not transfer the policy, but suspends it until the same person becomes the owner of both the policy and the thing insured. Okay. Kunwari, binenta mo yung kotse mo na naka-insure, it does not transfer the policy. Sinususpindi lamang ito until the same person becomes the owner nung bagay na naka-insure, in our example, yung kotse, at nung policy. Section 56. Nahirapan na yung mata ko magbasa. Section 56, a policy is either open, valued, or running. An open policy, sabi sa Section 57, is one in which the value of the thing insured is not agreed upon but is left to be ascertained in case of a loss. So, wala kayong usapan kung magkano yung halaga ng bagay na yun. Aalamin nyo na lamang ito in case of loss. Yun ang open policy. A valued policy, sabi sa Section 58, is one which expresses on its face an agreement that the thing insured shall be valued at a specified sum. Sakto, specific yung halaga. A running policy, sabi sa Section 59, is one which contemplates successive insurances and which provides that the object of the policy may be from time to time defined, especially as to the subjects of insurance by additional statements or endorsements. Okay? So, sunod-sunod na insurance, magkakasunod na insurance ang running policy, and which provides, sabi niya, na yung object ng policy, o siguro yung the object, kunwari kotse ito, may be from time to time defined, especially as to the subjects of insurance by additional statements or endorsement. Okay. Section 60, an acknowledgement in a policy of the receipt of premium in conclusive evidence of ulitin natin, sorry. An acknowledgement in a policy of the receipt. Kumbaga, ina-acknowledge ng insurance company o ng insurer the receipt of premium. Yun daw ay conclusive evidence of its payment so far as to make the policy binding, notwithstanding any stipulation therein that it shall not be binding until the premium is actually paid. Okay. Basta nakasaad na sa policy na natanggap na ng insurer ang premium, binding na raw yun. Section 61, an agreement made before a loss not to transfer the claim of a person insured against the insurer after the loss has happened is void. Hindi ko yun naintindihan. Ang isa raw agreement, sabi nila, na ginawa before mangyari yung loss o yung pagkasira, ganyan. Not to transfer the claim of a person insured against the insurer. Okay? Parang usapan na, o kahit may mangyaring kawalan, wala kaming kumbaga, hindi matatransfer yung claim sa amin, wala kang mahihita sa amin, sabi nung insurer. Void raw yun. Isang uri ng pag-uusap na, kahit masira itong kotse mo na in-insure mo sa amin, wala kang claim sa amin. Yun daw ay void. Siyempre naman. Ano ba naman klase? Sino ba naman taong papayag na? Kaya ako nga ini-insure para pag may loss, may makuha ako eh. Okay, warranties. Section 62. A warranty is either expressed or implied. A warranty may relate to the past, the present, the future, or to any or all of these. Sabi sa Section 63. Section 64, no particular form of words is necessary to create a warranty. 65. Every express warranty made at or before the execution of a policy must be contained in the policy itself or in another instrument signed by the insured and referred to in the policy as making a part of it. Section 66. A statement in a policy of a matter relating to the person or thing insured or to the risk as a fact is an express warranty thereof. Section 67. A statement in a policy which imports that it is intended to do or not to do a thing which materially affects the risk is a warranty that such act or omission shall take place. Section 68. When before the time arrives for the performance of a warranty relating to the future, a loss insured against happens or performance becomes unlawful at the place of the contract or impossible, the omission to fulfill the warranty does not avoid the policy. Okay. Ang sabi niya rito, kapag daw bago dumating yung oras ng performance ng warranty na may kinalaman sa future na pagkasira o pagkawala, future loss insured against, okay, pangyayari na kung saan naka-insure ka laban sa pangyayaring yun, o yung performance daw becomes unlawful at the place of the contract or imposible. The omission daw, yung hindi paggawa, yung hindi pag-fulfill ng warranty does not avoid the policy. Okay, hirap paliwanag, no? Ibig sabihin, yung hindi niya pag-fulfill dun sa warranty, hindi ibig sabihin nun, wala na kayong hindi nyo na masusundin yung nakalagay dun sa policy kasi kontrata yan di ba? Contract of insurance yan Section 69, the violation of a material warranty or other material provision of a policy on the part of either party thereto entitles the other to rescind. Alam na natin ibig sabihin ng rescind, to revoke, di ba? Section 70, a policy may declare that the violation of specified provisions thereof shall avoid it. Otherwise, the breach of an immaterial provision does not avoid the policy. Section 71, a breach of warranty without fraud merely exonerates an insurer from the time that it occurs or where it is broken in its inception prevents the policy from attaching to the risk. Tungo na tayo sa premium. Ito. Section 72, an insurer. Okay, yung insurance company daw, yung insurer yan, is entitled to payment of the premium soon as the thing insured is exposed to the peril insured against. Okay. Section 73, a person insured is entitled to a return of premium. Okay, kailan pwedeng bawiin nung insured yung kanyang ibinayad na premium sa insurance company? Letter A, to the whole premium if no part of his interest in the thing insured be exposed to any of the perils insured against. Hindi naman siya na-expose doon sa mga perils o yung mga danger na kung saan in-insure niya, pwede yung bawiin yung premium. Letter B, where the insurance is made for a definite period of time and the insured surrenders his policy to such portion of the premium as corresponds with the unexpired time at a prorata rate, unless a short period rate has been agreed upon and appears on the face of the policy after deducting from the whole premium any claim for loss or damage under the policy which has previously accrued, provided that no holder of a life insurance policy may avail himself of the privileges of this paragraph without sufficient cause as otherwise provided by law. Section 74, if a peril insured against has existed and the insurer has been liable for any period, however short, the insured is not entitled to return of premiums so far as that particular risk is concerned. Okay, hindi na daw pwedeng bawiin yan kasi na-expose ka naman dun sa peril o yung panganib kung saan mo ini-insure yung sarili mo. Section 75, a person insured is entitled to a return of the premium when the contract is voidable on account of the fraud or misrepresentation of the insurer or of his agent, or on account of facts the existence of which the insured was ignorant without his fault, or when by any default of the insured other than actual fraud, the insurer never incurred any liability under the policy. So, ang isang taong insured ay may karapatan na bawiin yung kanyang premium kapag daw yung kontrata ay naging voidable dahil sa fraud or misrepresentation, panggugulang ng mga at pagsisinungaling ng insurer, di ba? O ng mga insurance agents niya, di ba? Naging ginawa niyang ignorante yung kanyang kliyente, yung insured. Section 76, in case of an overinsurance by several insurers, the insured is entitled to a ratable return of the premium proportion to the amount by which the aggregate sum insured in all the policies exceeds the insurable value of the thing at risk. So, overinsurance, tingin ko parang naka-insure ka sa iba't ibang mga insurer, no? Yung insured daw is entitled to a ratable return, di ba? Parang ata-atadong pagbabalik kasi nagpa-insure ka sa iba't ibang insurance companies, eh. Okay, talakayin naman natin ang loss. Section 77, an insurer is liable for a loss of which a peril insured against was the proximate cause, although a peril not contemplated by the contract may have been a remote cause of the loss. But he is not liable, yung insurer daw is not liable for a loss on which the peril insured against was only a remote cause. Kung hindi naman yun ang direkta, sabi hindi yan ang proximate cause. Yun ay remote cause lamang, hindi daw liable ang insurer. Section 78, an insurer is liable where the thing insured is very insured against that would otherwise have caused a loss if in the course of such rescue the thing is exposed to a peril not insured against, which permanently deprives the insured of its possession in whole or in part, or where a loss is caused by efforts to rescue the thing insured from a peril insured against. Okay? Liable daw doon si insurer. Section 79, where a peril o yung panganib is specially specially exempted in a contract, di siya kasali doon sa contract of insurance. A loss which would not have occurred but for such peril is thereby exempted, although the immediate cause of the loss was a peril which was not exempted. Okay. Section 80, an insurer is not liable for insured. Okay, nakipag-connive, ang tawag dito, itong insured, mga kalokohan niya, willful act niya, 'di ba? Ng kalokohan niya, hindi liable ang insurer doon. But he is not exonerated by the negligence of the insured or of his agents or ang exonerated, ang ibig sabihin yung totally walang pananagutan. Parang hindi naman totally wala siyang pananagutan. Absolved, hindi naman siya absuelto doon sa meron pa rin. Okay. Notice of loss. So, balikan natin yan. Meron pa rin pananagutan ng insurance sa negligence ng insured or of his agents or others. Okay. Hindi nga lamang siya liable sa isang willful act. Di ba? Kunwari, naglasing-lasing. Tapos, biglang in-insure niya yung buhay niya. Nagpasagasa naman siya. O sabuatan siya sa isang sasakyan para sagasaan siya, kunwari. Yun. Hindi reliable yung insurer doon. Okay, notice of loss. Section 81, in case of loss upon an insurance against fire, an insurer is exonerated if notice thereof be not given to him by some person insured or entitled to the benefit of the insurance without unnecessary delay. Section 82, when preliminary proof of loss is required by a policy, the insured is not bound to give such proof as would be necessary in a court of justice but it is sufficient for him to give the best evidence which he has in his power at the time. Okay. Okay. So kailangan i-notify mo yung insurance. Okay. Yun yung sinasabi sa section 81. I-notify mo yung insurance kapag ka yung loss sanhi ng fire, ganyan. Section 82 naman sabi, when preliminary proof of loss is required, may pruweba ka ng pagkasira ng in-insure mo na bagay, the insured daw is not bound to give such proof as would be necessary in a court of justice. Hindi kailangan ng pruweba na kailangan sa korte. Ang kailangan mo lang ibigay dito yung best evidence na meron ka. Section 83, all defects in a notice of loss or in preliminary proof thereof which the insured might remedy and which the insurer omits to specify to him without unnecessary delay as grounds of objection are waived. Okay. Okay. Section 84, delay in the presentation to an insurer of notice or proof of loss is waived if caused by any act of his or if he omits to take objection promptly and specifically upon that ground. Okay. Pero ang advice ko sa inyo, huwag kayong madidelay. Pag may nangyari, notify nyo agad yung insurance nyo. Section 85, if a policy requires by way of preliminary proof of loss, the certificate or testimony of a person other than the insured, it is sufficient o sapat na raw for the insured to use a reasonable diligence to procure it o kunin yung testimonya ng ibang tao. And in case of the refusal of such person to give it, then furnish reasonable evidence to the insurer that such refusal was not induced by any grounds of disbelief in the facts necessary to be certified. So sa panahon ngayon, madali naman na may picture, may video recording, mas madali na ngayon. Okay, ano naman ang double insurance? Section 86. A double insurance exists where the same person is insured by several insurers separately in respect to the same subject and interest. Same subject and interest, kunwari kotse. Meron kang kotse. Yung particular na kotse mo na in-insure mo sa iba't ibang mga insurance company. Section 87, where the insured is over-insured by double insurance, ang mangyayari daw, letter A. The insured, unless the policy otherwise provides, may claim payment from the insurers in such order as he may select, up to the amount for which the insurers are severally liable under their respective contracts. Letter B, where the policy under which the insured claim is a valued policy, the insured must give credit as against the valuation for any sum received by him under any other policy without regard to the actual value of the subject matter insured. Letter C, where the policy under which the insured claims is an unvalued policy, he must give credit as against the full insurable value for any sum received by him under any other policy. Letter D, where the insured receives any sum in excess of the valuation in the case of valued policies and the insurable value in the case of unvalued policies, he must hold such sum in trust for the insurers according to their right of contribution among themselves. And letter E, each insurer is bound as between himself and the other insurers to contribute ratably to the loss in proportion to the amount for which he is liable under contract. So, may dagdag ko lang. Ang date ngayon ay November 20, 2020. Simula nung, kailan ba yan? January, February, March. Simula nung March, hindi na natigil yung pag, hindi, dapat mas matinis. Pag ganun-ganon, senyales yun na pumasok na kayo at huwag na kayo lalabas ng bahay. 8 o'clock PM na kasi, bawal na lumabas. COVID pa rin. Visit na COVID yan. Sa mga nakakapanood nito sa hinaharap, sa mga magiging abogado o magiging makapangyarihang tao sa hinaharap, labanan niyo yung mga gumagawa ng virus na yan. Mauubos tayo dyan. Okay, reinsurance, Section 88. A contract of reinsurance is one by which an insurer procures a third person to insure him against loss or liability by reason of such original insurance. Aba, si insurance company, pina-insure niya yung sarili niya sa third person, di ba? Section 89, where an insurer obtains reinsurance, he must communicate all the representations of the original insured and also all the knowledge and information he possesses, whether previously or subsequently acquired, which are material o mahalaga to assess the risk. Section 90, a reinsurance is presumed to be a contract of indemnity against liability and not merely against damage. So, ulitin natin. A reinsurance is presumed to be a contract of indemnity against liability and not merely against damage. Okay? Okay. Basahin lang natin ito. Ang ibig sabihin ng indemnity ay security or protection against a loss or other financial burden. 'Di ba? So, ang reinsurance daw ay pinagpapalagay na isang kontrata ng indemnity, sabi niya. Indemnity o yung security against or exemption security or protection against a loss or financial burden. Indemnity siya against liability. Security siya, protection siya against liability and not merely against damage. Section 91, the original insured has no interest in a contract of reinsurance. So, wala na siyang pakialam dyan. Kasi ang nag-uusap sa reinsurance, yung insurance company at yung kung kanino siyang nagpa-insure. Pina-insure niya yung sarili niya eh. Na ang sanhi ng insurance niya ay yung insurance na kinuha sa kanya. Yun ang reinsurance. Okay? So, papahinga lang ako. Dapat tapos na ako eh. Pero pag-iisipan ko, pag kaya ko pa mamaya-maya, basahin natin itong marine insurance. Diyan lang kayo. Okay, so ako pinagbabalik at basahin na natin ang Chapter 2 ng Insurance Act, di ba? Pinamagatang Marine Insurance. Okay. Section 92. Marine insurance is an insurance against risks connected with navigation to which a ship, cargo, freightage, profits, or other insurable interest in movable property may be exposed during a certain voyage or a fixed period of time. Okay. Sandali lang yung acid ko. Kailangan ko na yata magpa-insure. Or uminom ng insure. Okay, insurable interest. Section 93. The owner of a ship has in all cases an insurable interest in it, even when it has been chartered by one who covenants to pay him its value in case of loss, provided that in this case the insurer shall be liable for only that part of the loss which the insured cannot recover from the charterer. Okay. So, ang isang may-ari daw ng barko ay lagi siyang may insurable interest dun sa kanyang barko. Kahit pa ito ay nirentahan ng ibang tao at nangako ang taong ito na babayaran ka kung may mangyayari man doon sa barko. Okay. Section 94, the insurable interest of the owner of a ship hypothecated by bottomry is only the excess of its value over the amount secured by bottomry. Maaring basahin na, makita natin yung ibig sabihin ng bottomry as we move along, ano? Pero hanapin na natin siya ngayon. Bottomry. Okay. Ibig sabihin ng bottomry, a system of merchant insurance in which a ship is used as security against a loan to finance a voyage, the lender losing the investment if the ship sinks. Okay? Ang isang barko daw ay ginamit as security against a loan to finance a voyage. Okay? So yung barko yung parang pinaka-collateral, no? Sa isang loan to finance a voyage, the lender losing the investment if the ship sinks. Yung nangutang, nalulose niya ang investment if the ship sinks. Kasi ang ginamit niyang security yung yung barko di ba? Okay. So yun pala ibig sabihin ng bottomry. The lender loses, the lender losing the investment if the ship sinks. Kasi yung nangutang, ginamit niyang collateral, yung barko, to finance a voyage. So kapag yung barko lumubog, ano pang security niya nung nangutang, di ba? So sabi rito, the insurable interest of the owner of a ship hypothecated by bottomry is only the excess of its value over the amount secured by bottomry. Okay. So ang insurable interest daw ng may-ari ng barko na subject ng isang bottomry is only the excess of the value na ipinahiram sa kanya. Okay, excess. Kasi nabigyan na siya ng pera di ba? Dahil ginawa niya ang collateral, yung barko niya. So yung excess doon, yun na lang ang yun ang insurable interest ng owner ng barko na pinang-collateral sa bottomry. Okay. Ulitin natin, ang bottomry ay isang loan to secure loan na nangutang ka para gamitin mo yung perang yon sa paglalayag at ang ginamit mong security o collateral ay ang barko. So kung lumubog yung barko, mawawala ng collateral. Ang natalo dito yung nangutang, di ba? Section 95, freightage. In the sense of a policy of marine insurances, signifies all the benefit derived by the owner, either from the chartering of the ship or its employment for the carriage of his own goods or those of others. Section 96. The owner of a ship has an insurable interest in expected freightage, which according to the ordinary and probable course of things he would have earned but for the intervention of a peril insured against or other peril incident to the voyage. So yung may-ari daw ng barko has an insurable interest in expected freightage. Okay? Which according to the ordinary and probable course, binasa natin ulit, no? He would have earned but for the intervention of a peril insured against or other peril incident to the voyage. Section 97, the interest mentioned in the last section exists in the case of a charter party when the ship has broken ground on the chartered voyage, and if a price is to be paid for the carriage of goods when they are actually on board, or there is some contract for putting them on board, and both ship and goods are ready for the specified voyage. Okay. Section 98. One who has an interest in the thing from which profits are expected to proceed has an insurable interest in the profits. Siyempre ha. Section 99. The charterer of a ship has an insurable interest in it to the extent that he is liable to be damnified by its loss. Okay, kumbaga nirentahan mo yung ship eh. Ikaw ang may control dun sa ship na yun. So, meron kang insurable interest dun. Kasi ikaw yung mapeperwisyo pag nawala yung nirentahan mong barko. Okay, concealment, section 100. In marine insurance, each party is bound to communicate in addition to what is required by section 27 all the information which it possesses material to the risk, except such as is mentioned in section 29, and to state the exact and the whole truth in relation to all matters that he represents or upon inquiry discloses or assumes to disclose. Section 101, in marine insurance, information of the belief or expectation of a third person in reference to a material fact is material o kumbaga may bigat, may halaga. Section 102, a person insured by a contract of marine insurance is presumed to have knowledge at the time of the insuring of a prior loss of the information might possibly have reached him in the usual mode of transmission and at the usual rate of communication. Okay, section 103. A concealment in a marine insurance in respect to any of the following matters does not vitiate the entire contract but merely exonerates the insurer from a loss resulting from the risk concealed. Okay? Yung concealment daw sa isang marine insurance in respect to national character of the insured, letter B, the liability of the thing insured to capture and detention, letter C, the liability to seizure from breach of foreign laws of trade, letter D, the want of necessary documents and yung kakulangan sa dokumento, and letter E, the use of false and simulated papers. So itong mga to, itong concealment ng mga bagay natin na nabanggit does not vitiate the entire contract but merely exonerates the insurer. So wala nang pananagutan yung insurer from a loss resulting from the risk na itinago mo. Representations, kaya kailangan pag pumasok ka sa isang kontrata, honest ka sa material facts. Kasi madalas ang lilin lang nakakarma. Ikaw din ang mahihirapan, di ba? Representations, section 104. If a representation by a person insured by a contract of marine insurance is intentionally false in any material respect or in respect of any act on which the character and nature of the risk depends, the insurer may rescind. Yung insurer daw o yung insurance company may rescind the entire contract. Section 105. The eventual falsity of a representation as to expectation does not, in the absence of fraud, avoid a contract of insurance. So, merong mali dun sa representation. Pero wala namang fraud. Nagkamali lang. Hindi naman ibig sabihin nun na mawawala na ng visa yung kontrata ng insurance. Meron pa rin. Okay. Implied warranties. Ayan, medyo mahaba-haba ito ha. Implied warranties, Section 106. In every marine insurance upon a ship or freight or freightage or upon anything which is the subject of marine insurance, a warranty is implied that the ship is seaworthy. Section 107. A ship is seaworthy when reasonably fit to perform the services and to encounter the ordinary perils of the voyage contemplated by the parties to the policy. Okay. Section 108. An implied warranty of seaworthiness is complied with if the ship be seaworthy at the time of the commencement of the risk. Okay. Maliban na lamang or except in the following cases. Letter A. When the insurance is made for a specified length of time, the implied warranty is not complied with unless the ship be seaworthy at the commencement of every voyage she may undertake during the time. And letter B. Okay, when the insurance is upon the cargo, which, by the terms of the policy, or the description of the voyage, or the established custom of the trade, is so to be transshipped at an intermediate port, the implied warranty is not complied with unless each vessel upon which the cargo is shipped or transshipped be seaworthy at the commencement of its particular voyage. Okay? So sabi niya, meron daw implied warranty of seaworthiness. Kapag ka yung ship ay seaworthy at the time ng pag-commence o ng pagpapatuloy ng mga risks, maliban na lamang, yun nga sa mga nabanggit. Yung insurance is made para lamang sa specified length of time. Yung implied warranty nun ay hindi na natutugunan. Maliban na lamang kung yung ship ay seaworthy at the commencement of kumbaga, worthy siya at every voyage, di ba? At kapag yung insurance daw ay para sa cargo, okay? At ililipat ang cargo nito sa isang intermediate port, the implied warranty raw ay hindi na nako-comply, okay? Maliban na lamang kung yung mga vessels daw upon which the cargo is shipped or transshipped ay seaworthy siya. Kumbaga, para ma-comply mo yung seaworthiness, kailangan seaworthy ka sa bawat paglalayag mo. Diba? Sa bawat, kasi pag naglayag ka, risk yun eh. Bawat paglalayag ay risk. So, kailangan seaworthy ka. Okay. Section 109, a warranty of seaworthiness extends not only to the condition of the structure of the ship itself, hindi lamang yun, but requires that it be properly laden and provided with a competent master, a sufficient number of competent officers and seamen, and the requisite appurtenances and equipment such as ballast, cables, and anchors, cordage, and sails, food, water, fuel, and lights, and other necessary or proper stores and implements for the voyage. Section 110, where different portions of the voyage contemplated by a policy differ in respect to the things requisite to make the ship seaworthy, a warranty of seaworthiness is complied with if, at the commencement of each portion, the ship is seaworthy with reference to that portion. Section 111, when a ship becomes unseaworthy during the voyage to which an insurance relates, an unreasonable delay in repairing the defect exonerates the insurer from liability from any loss arising therefrom. So, kung kunwari, nagka-problema yung barko mo, hindi na-delay ngayon, hindi mo ni-repair kaagad, nawawala na raw yung pananagutan ng insurer doon. Section 112, a ship which is seaworthy for the purpose of an insurance upon the ship may, nevertheless, by reason of being unfitted to receive the cargo, be unseaworthy for the purpose of insurance upon the cargo. Section 113, where the nationality or neutrality of a ship or cargo is expressly warranted, it is implied that the ship will carry the requisite documents to show such nationality or neutrality, and that it will not carry any documents which cast reasonable suspicion thereon. Okay? So, mahalaga lahat ng mga dokumento. Okay? The voyage and deviation, Section 114. When the voyage contemplated by a policy is described by the places of beginning and ending, the voyage insured is one which conforms to the course of sailing fixed by mercantile usage between those places. Section 115, if the course of sailing is not fixed by mercantile usage, the voyage insured by a policy is the way between the places specified, which to a master of ordinary skill and discretion would seem the most natural, direct, and advantageous. Hindi nakasaad kung saan ang ruta mo. So, yung pinaka-practical at pinaka-safe, doon tayo dadaan, sabi. Section 116, deviation is a departure from the course of the voyage insured mentioned in the last two sections or an unreasonable delay in pursuing the voyage or the commencement of an entirely different voyage. So sabi sa Section 117, a deviation is proper, letter A, when caused by circumstances over which neither the master nor the owner of the ship has any control. Kunwari, inaanod sila, no? Letter B, when necessary to comply with the warranty or to avoid a peril, whether insured against or not, may iniwasan kang panganib kahit na subject yon ng insurance o hindi. Letter C, when made in good faith and upon reasonable grounds of belief in its necessity to avoid peril. And letter D, when made in good faith for the purpose of saving human life or relieving another vessel in distress. Maliban sa mga nabanggit na ito, sinasabi sa Section 118 na every deviation not specified in the last section is improper. So kapag hindi ka sumunod sa ruta at wala naman sa mga nabanggit, yung dahilan mo bakit ka lumisya sa ruta, the deviation is improper. Section 119, an insurer o yung sa atin layman's term, lagi kong sinasabi yung insurance company. Okay, an insurer is not liable for any loss happening to a thing insured subsequently to an improper deviation. Okay. Magtungo naman tayo sa loss. Okay, Section 120, a loss may be either total or partial. 121, every loss which is not total is partial. 122, a total loss may either actual or constructive. Section 123, an actual total loss is caused by letter A, a total destruction of the thing insured. Letter B, the loss of the thing by sinking or by being broken up. Letter C, any damage to the thing which renders it valueless to the owner for the purposes for which he held it. Or letter D, any other event which entirely deprives the owner of the possession at the port of destination of the thing insured. Section 124, a constructive total loss is one which gives to a person insured a right to abandon under Section 132. Okay, kasi constructive total loss, may karapatan ka ng to abandon ship. Section 126, an actual loss may be presumed from the continued absence of a ship without being heard of, and the length of time which is sufficient to raise this presumption depends on the circumstances of the case. Section 126, when a ship is prevented at an intermediate port from completing the voyage by the perils insured against, the master must make every exertion to procure in the same or a contiguous port another ship for the purpose of conveying the cargo to its destination. So kailangan daw yun. And the liability of a marine insurer thereon continues after they are thus reshipped. Siguro to insurance sa cargo, no? Kapag daw kunwari hindi na maayos yung barko, no? Kailangan daw yung master gawin niya lahat ng makakaya niya para makakuha siya ng ibang barko at doon niya muling maisakay yung mga cargo at mailipat ito doon sa kanilang dapat napuntahan. Section 127, in addition to the liability mentioned in the last section, a marine insurer daw is bound for damages, expenses of discharging, storage, reshipment, extra freightage, and all other expenses incurred in saving cargo reshipped pursuant to the last section up to the amount insured. Section 128, upon an actual total loss, a person insured is entitled to payment without notice of abandonment. Kasi actual total loss, hindi na kailangan ng notice of abandonment para si insured ay makakuha ng payment. Section 129, where it has been agreed that an insurance upon a particular thing or a class of things shall be free from particular average loss, not depriving the insured of the possession at the port destination of the whole of such thing or class of things, even though it becomes entirely worthless. But he is liable for his proportion of all general average loss assessed upon the thing insured. Section 130. An insurance confined in terms to an actual total loss does not cover a constructive total loss but covers any loss which necessarily results in depriving the insured of the possession at the port of destination of the entire thing insured. Okay. Ang sabi rito, ang insurance ah, na nasa terms ng actual total loss, hindi niya kinocover yung constructive total loss. Kinocover niya lang yung kinocover niya lang yung deprivation ng insured from possession ng mga bagay, siguro cargo ito, na naka-insure. Hindi, okay. Abandonment, okay. Pag-usapan natin ang abandonment. Hindi lang po nangyayari yan sa bata, kundi pati sa ship. Section 131, abandonment is the act by which, after a constructive total loss, a person insured by contract of marine insurance declares to the insurer that he relinquishes to him his interest in the thing insured. Okay. Wala na akong interest dyan sa in-insure ko sa'yo. Sabi nung insured kay insurer. Section 132. A person insured by a contract of marine insurance may abandon the thing insured or any particular portion thereof separately valued by the policy or otherwise separately insured and recover for total loss thereof when the cause of the loss is a peril insured against. Letter A. If more than 3/4 thereof in value is actually lost or will have to be expended to recover it from the peril. Letter B. If it is injured to such an extent as to reduce its value more than 3/4. Letter C. If the thing insured being a ship, the contemplated voyage cannot be lawfully performed without incurring an expense to the insured of more than 3/4 the value of the thing abandoned, or without incurring a risk which a prudent man would not take under the circumstances. Or letter D. If the thing insured being a cargo or freightage, the voyage cannot be performed, nor another ship procured by the master within a reasonable time and with reasonable diligence to forward the cargo without incurring the like expense or risk. But freightage cannot in any case be abandoned unless the ship is also abandoned. Okay? Yun ang mga sinasabi niya. Okay? Okay. Section 133, an abandonment must be neither partial nor conditional. Okay. Hindi siya partial abandonment, hindi rin siya conditional abandonment. Section 134, an abandonment must be made within a reasonable time after receipt of reliable information of the loss. But where the information is of a doubtful character, the insured is entitled to a reasonable time to make inquiry. Okay. Section 135, where the information upon which an abandonment has been made proves incorrect, or the thing insured was so far restored when the abandonment was made that there was then in fact no total loss, the abandonment becomes ineffectual. Okay. Balikan natin yung isa 134. Sinasabi rito na kung hindi naman reliable yung source na kailangan, para bang may report na, uy, mayroon ng total destruction, kailangan na natin i-abandon ito. Pero hindi reliable yon. Yung insured ay may karapatan ng reasonable time to make inquiry. Ngayon, bakit sinasabi itong reasonable time na ito? Para makasingil pa rin siya, para hindi ito masisi sa kanya na, oops, hindi mo naman inagapan eh. Pwede niyang sabihin na, hindi ko naagapan kasi I need reasonable time to make inquiry, and then bigla na lang nagkaroon ng distraction. Yun ang purpose yan. Okay, nasa na ako? Section 136, abandonment is made by giving notice thereof to the insurer, which may be done orally or in writing. Section 137, a notice of abandonment must be explicit and must specify the particular cause of the abandonment, but need state only enough to show that there is probable cause, therefore, and need not be accompanied with proof of interest or of loss. Section 138, an abandonment can be sustained only upon the cause specified in the notice thereof. Okay. Section 139, an abandonment is equivalent to a transfer by the insured of his interest to the insurer with all the chances of recovery and indemnity. So, pag inabandon naman yung barko, hindi naman niya sinabing barko, pero yung abandonment na lang. An abandonment is equivalent daw sa paglilipat nung insured ng kanyang interest kay insurer. Pati daw yung mga tsansa niya na makarecover at ma-indemnify. Section 140, if a marine insurer pays for a loss as if it were an actual total loss, he is entitled to whatever may remain of the thing insured or its proceeds or salvage as if there had been a formal abandonment. Okay. So, kung binayaran ni insurer, di ba, yung loss, kung ano man yung matitira doon, di ba, kung may natira, kung mayroong na salvage na mga parts, kunwari, o bahagi ng barko, entitled doon si insurer kasi nagbayad siya di ba? Section 141, upon abandonment, acts done in good faith by those who were agents of the insured in respect to the thing insured, subsequent to the loss, are at the risk of the insurer and for his benefit. Section 142, where notice of abandonment is properly given, the rights of the insured are not prejudiced by the fact that the insurer refuses to accept the abandonment. Okay. Properly given naman yung notice mo dun sa insurer ng abandonment, di ba? Hindi niya ito in-accept. O, edi, yung karapatan ng insured ay ganun pa rin. Hindi siya wala hindi mo tinanggap di ba? Section 143, the acceptance of an abandonment may be either expressed or implied from the conduct of the insurer. The mere silence of the insurer after notice is not to be construed as an acceptance. Section 144, the acceptance of an abandonment, whether expressed or implied, is conclusive upon the parties and admits the loss and the sufficiency of the abandonment. Section 145, an abandonment once made and accepted is irrevocable unless the ground upon which it was made proves to be unfounded. Okay. Yung abandonment, irrevocable yan. Hindi mo yan pwedeng palitan na. Unless yung ground mo kung bakit mo siya inabandona ay wala naman talagang basihan. Section 146, on unaccepted abandonment of a ship. Ito maganda, mas malino kasi merong of a ship, abandonment of a ship. Freightage. Ayan, freightage earned previous to the loss belongs to the insurer of said freightage. Okay? So yung kinita ng freightage bago pa yung loss ng ship belongs to the insurer of said freightage. But freightage subsequently earned belongs to the insurer of the ship. Okay. Section 147, if an insurer refuses to accept a valid abandonment, okay, ayaw niyang tanggapin. Valid yung dahilan mo para i-abandon mo yung ship, ayaw niyang tanggapin. He is liable. Yung insurance company o yung insurer is liable as upon an actual total loss, deducting from the amount any proceeds of the thing insured which may have come to the hands of the insured. Section 148, if a person insured omits to abandon, okay, hindi niya iniwanan yung ship, he may nevertheless recover his actual loss. Okay. Kailangan, ang para sa akin dyan, mahalaga, notice. Yung notice of abandonment, kung kinakailangan, meron kang proper grounds. Okay. Kung hindi mo daw yun ginawa, maaaring wala ka ng ma-recover dun sa iyong losses. Punta naman tayo sa measure of indemnity. Okay. Section 149. A valuation in a policy of marine insurance is conclusive between the parties thereto in the adjustment of either a partial or total loss if the insured has some interest at risk and there is no fraud on his part. Except that when a thing has been hypothecated by bottomry or respondencia, ay sinasabi natin kanina, before its insurance and without the knowledge of the person actually procuring the insurance, he may show the real value. But a valuation fraudulent in fact entitles the insurer to rescind the contract. As a general rule naman, kahit anong batas yung pag-usapan natin, pag may fraud, you are entitled to rescind or revoke the contract. Section 150, a marine insurer is liable upon the partial loss only for such proportion of the amount insured by him as the loss bears to the value of the whole interest of the insured in the property insured. Section 151, where profits are separately insured in a contract of marine insurance, the insured is entitled to recover, in case of a loss, a proportion of such profits equivalent to the proportion which the value of the property lost bears to the whole value of the whole. Bears to the value of the whole. Section 152, in case of a valued policy of marine insurance on freightage or cargo, if a part only of the subject is exposed to risk, the valuation applies only in proportion to such part. Okay. Yung part lang na na-expose sa risk. Section 153, when profits are valued and insured by a contract of marine insurance, o yung kita in-insure, a loss of them is conclusively presumed from a loss of the property out of which they were expected to arise, and the valuation fixes their amount. Section 164, in estimating a loss under an open policy of marine insurance, the following rules are to be observed. Letter A, the value of the ship is its value at the beginning of the risk, including all articles or charges which add to its permanent value or which are necessary to prepare it for the voyage insured. Letter B, the value of cargo is its actual cost to the insured when laden on board or where that cost cannot be ascertained, its market value at the time and place of lading, adding the charges incurred in purchasing and placing it on board without reference to any losses incurred in raising money for its purchase or to any drawback on its exportation or to the fluctuations of the market at the port of destination or to expenses incurred on the way or on arrival. Letter C, the value of freightage is the gross freightage exclusive of primage without reference to the cost of earning it. And letter D, the cost of insurance is in each case to be added to the value thus estimated. Okay. Okay. So, ang ibig sabihin pala ng primage, kasi hindi ko naintindihan, exclusive of primage eh. So, ang sabi rito doon sa letter C, the value of freightage is the gross freightage exclusive. Hindi pa kasama yung primage. Ang primage ay ang small payment made by shippers to the captain of a ship for his special care of their goods. It's also called the hot money. So, yun pala ang primage. Section 155, if cargo insured against partial loss arrives at the port of destination in a damaged condition, the loss of the insured is deemed to be the same proportion of the value which the market price at the port of the thing so damaged bears to the market price it would have brought if sound. Ang hirap magbasa, puro bigla na lang may kama. Okay, wait lang. 155, no? Saan na tayo? 155. Okay. 156. Section 156. A marine insurer is liable for all expenses attendant upon a loss which forces the ship into port to be repaired And where it is stipulated in the policy that the insured shall labor for the recovery of the property, the insurer is liable for the expense incurred thereby, such expense, in either case, being in addition to a total loss, if that afterwards occurs. Section 157, a marine insurer is liable for a loss falling upon the insured through a contribution in respect to the thing insured required to be made by him towards general average loss called for by a peril insured against. Section 158, when a person insured by a contract of marine insurance has a demand against others for contribution, he may claim the whole loss from the insurer, subrogating him to his own right to contribution. But no such claim can be made upon the insurer after the separation of the interests liable to contribution, nor when the insured, having the right and opportunity to enforce contribution from others, has neglected or waived the exercise of that right. Section 159. In the case of a partial loss of a ship or its equipment, the old materials are to be applied towards payment for the new, and unless other conditions are stipulated in the policy, a marine insurer is liable for the remaining cost of repairs, less deductions from such cost to be made in accordance with the following rules. Number 1. In the case of iron or steel ships, from date of original register to the date of accident. Letter A, up to 1 year old, all repairs to be allowed in full, except painting or coating of bottom, from which 1/3 is to be deducted. Letter B, between 1 and 3 years, 1/3 to be deducted of repairs to and the renewal of woodwork, of hull, masts and spars, furniture, upholstery, crockery, metal and glassware, also sails, rigging, ropes, sheets and hawsers. Okay. 1/6 daw to be deducted of wire rigging, wire ropes and wire hawsers, chain cables and chains. Punta na tayo, letter C, between 3 and 6 years daw. Okay, sandali lang. Okay, so yung nababanggit natin yung mga deductions, okay? Kasi ang liable dito yung insurer eh. Letter D, between 6 and 10 years, deductions as above under clause. Okay? Except that 1/3 be deducted of ironwork, of masts and spars repairs and renewal of all machinery, riggings and sheets, ropes. Letter E, between 10 and 15 years, 1/3 daw ang to be deducted of all repairs and renewals except ironwork of hull, cementing and chain cables. Letter F, over 15 years, 1/3 to be deducted of all repairs and renewals, anchors to be allowed in full, 1/6 to be deducted off. Okay, yun ang sinasabi sa section 159, no? Na in the case of partial loss of a ship or yung equipment, old materials daw are to be applied towards payment for the new, and unless other conditions are stipulated in the policy, okay, a marine insurer is liable for the remaining cost of repairs, minus or less deductions from such costs to be made. Okay, so ito yung mga mina-minus na deductions, no? Okay, basahin natin yung letter G. Deductions pa rin siya, hindi ko siya natapos anuhin. Pero basahin na rin natin. Sabi kasi dito, generally, the deductions daw to be regulated by the age of the ship and not the age of the particular part of her to which they apply. So, yung edad ng barko ang titingnan mo para sa mga deductions, no? No painting bottom to be allowed if the bottom has not been painted within 6 months previous to the date of accident. No deduction to be made in respect of old material which is repaired without being replaced by new, and provisions in stores which have not been in use. Okay. In the case of wooden or composite ships, ito yung mga marami sa ating kababayan, ito yung mga mahingisda nating kababayan. When a ship is under 1 year old, okay, from date of original register at the time of accident, under 1 year old daw, from the date of original register at the time of accident, no deduction new for old shall be made, okay? After that period, a deduction of 1/3 shall be made with the following exceptions. Okay. Ulitin natin, sabi niya rito, kapag ka daw under 1 year old from the date of original register yung barko o yung bangka, wooden bangka at wooden composite ships at the time of the accident, no deduction new for old shall be made. Pero matapos ang period na yon, a deduction of 1/3 shall be made, sabi. Maliban, ito yung mga exceptions, hindi ka pa rin magdededuct para sa mga anchors kasi anchors shall be allowed in full, sabi. Chain cables shall be subject to a deduction of 1/6 only. Okay. No deduction shall be made in respect of provisions in stores which had not been in use. Metal sheathing shall be dealt with by allowing in full the cost of a weight equal to the gross weight of metal sheathing, stripped off minus the proceeds of the old metal. Nails, felt, and labor metaling are subject to the deduction of 1/3. Okay. Okay yan eh. Old materials ginagamit kasi para sa pagbabayad ng new. Okay, tapos yung marine insurer, liable siya sa mga natitirang cost ng repairs. Okay. Okay, magtungo na tayo sa chapter 3. Fire insurance. Marami-rami pa tayong babasahin. Pero simulan na natin bago tayo mag-break. Chapter 3, Fire Insurance, Section 160. An alteration in the use or condition of a thing insured from that to which it is limited by the policy made without the consent of the insurer by means within the control of the insured and increasing the risk entitles an insurer to rescind the contract of fire insurance. Okay. Kasi meron ka daw alteration in the use or condition nung bagay na in-insure mo. Kaya yung policy, nalimitahan siya. Diba? Nang walang pahintulot ng insurer o ng insurance company. Section 161, an alteration in the use or condition of a thing insured from that to which it is limited by the policy which does not increase the risk, does not affect a contract of fire insurance. Mahaba-haba itong mga susunod. Section 162, a contract of fire insurance is not affected by any act of the insured subsequent to the execution of the policy which does not violate its provisions, even though it increases the risk and is the cause of a loss. Section 163, if there is no valuation in the policy, the measure of indemnity in an insurance against fire is the expense it would be to the insured at the time of the commencement of the fire to replace the thing lost or injured in the condition in which it was at the time of the injury. But the effect of evaluation in a policy of fire insurance is the same as in a policy of marine insurance. Section 164, whenever the insured desires to have a valuation named in his policy, insuring any building or structure against fire, he may require such building or structure to be examined by the insurer, and the value of the insured's interest therein shall be thereupon fixed by the parties. The cost of such examination shall be paid for by the insured. A clause shall be inserted in such policy stating substantially that the value of the insured's interest in such building or structure has been thus fixed. In the absence of any change increasing the risk without the consent of the insurer or of fraud on the part of the insured, then in case of a total loss under such policy, the whole amount so insured upon the insured's interest in such building or structure, as stated in the policy upon which the insurers have received the premium, shall be paid. And in the case of a partial loss, the full amount of the partial loss shall be so paid. And in case there are two or more policies covering the insured's interest therein, each policy shall contribute pro rata to the payment of such whole or partial loss. But in no case shall the insurer be required to pay more than the amount thus stated in such policy. This section shall not prevent the parties from stipulating in such policies concerning the repairing, rebuilding, or replacing buildings or structures wholly or partially damaged or destroyed. Okay, Chapter 5, Life and Health Insurance. Section 165, an insurance upon life may be made payable on the death of the person or on his surviving a specified period or otherwise contingently on the continuance or cessation of life. Okay. So, kung kunwari pala daw, hindi namatay yung person sa isang takdang oras, pwedeng bayaran siya. Di ba? Okay. Every contract or pledge for the payment of endowments or annuities shall be considered life insurance contract for the purposes of this act. Okay. Section 166, a policy of insurance upon life or health may pass by transfer, will, or succession to any person whether he has an insurable interest or not, and such person may recover upon it whatever the insured might have recovered. Okay, so yung policy pala ng insurance upon life or health ay pwedeng ipasa by transfer, will, or succession. Okay. Section 167, notice to an insurer of a transfer or bequest thereof is not necessary to preserve the validity of a policy. Okay. Not necessary to preserve the validity of a policy of insurance upon life or health unless thereby expressly required. Pag hindi naman expressly required, yung notice to an insurer ay hindi naman necessary ng pagpasa. Okay? Transfer ng life insurance. Section 168, unless the interest of a person insured is susceptible of exact pecuniary measurement. Okay, yung susukatin mo siya sa halaga ng pera. The measure of indemnity under a policy of insurance upon life or health is the sum fixed in the policy. Tungo na tayo Chapter 5, Insurance Companies. Nako, mahaba-haba ito. Okay. Mahaba yung insurance companies. Okay, basahin na rin natin. Pahapyaw-hapyawan natin. Okay, Chapter 5, Insurance Company, Section 169. In addition to the duties now imposed upon him by law, the insular treasurer shall act as insurance commissioner, and in addition to his present office, present official title, he shall thereafter be designated as insurance commissioner ex officio. Maaring na iba na to, no? Maaring may pagbabago na rito. Section 170, for the purposes of this chapter, unless the context otherwise requires, the terms company or insurance company shall include all corporations, associations, partnerships, or individuals engaged as principals in the insurance business, excepting fraternal and benevolent orders and societies. Domestic companies shall include companies formed and organized or existing under the laws of the Philippine Islands. Foreign companies naman, when used without limitation, shall include companies formed, organized, or existing under any laws other than those of the Philippine Islands. Section 171, it shall be the duty of the insurance commissioner to see that all laws relating to insurance and insurance companies are faithfully executed and perform the duties imposed upon him by this act. He may issue such rulings, instructions, and orders as he may deem necessary to secure the enforcement of the provisions of this act, subject to the approval of the Secretary of Finance and Justice. Ganun pa rin kaya to sa ngayong 2020. Section 172, after the becoming effective of this act, no foreign or domestic insurance company shall transact any new business in the Philippine Islands until after it shall have obtained a certificate of authority. Similar din doon sa corporation, ano? Kasi nga doon sa nabasa natin sa corporation code, kailangan nilang humingi ng certificate of authority ng mga kumpanya na magnenegosyo rito, mga korporasyon na magnenegosyo rito. Kailangan nilang humingi ng certificate of authority from the proper government agency, at saka yung mga required na kailangan nilang ipasa, kailangan pasa nila na meron silang good standing, good financial standing, yan, mga ganyan. Okay. Okay, mga powers na ng insurance commissioner to, etc. Okay, sabi lang dito. Okay, Section 173, the insurance commissioner shall require each insurance company to keep its books, records, accounts, and vouchers in such manner that he or his authorized representatives may readily verify his annual statement at masiguro nila whether the company is solvent, okay, may sapat ka bang kabayaran, ay may sapat ka bang pera, o nakakomply ka ba sa provisions ng Insurance Act. Section 174, the insurance commissioner shall at least once a year, and whenever he considers the public interest so demands, cause an examination to be made into the financial condition of every domestic insurance company. Okay. Dapat ginagawa yan ni commissioner, ha? Section 175, if the insurance commissioner is of the opinion upon examination that any foreign or domestic insurance company is in an unsound condition or that it has failed to comply with any provision of law obligatory upon it. Sabi, okay, pwede niya raw i-revoke, di ba? The insurance commissioner is authorized subject to appeal to Secretary of Finance and Justice. Insurance Commissioner is authorized to revoke or suspend all certificates of authority granted to such insurance company, its officers or agents, and no new business shall thereafter be done by such company or for such company by its agents in the Philippine Islands while such revocation, suspension, or disability continues or until its authority to do business is restored by the Insurance Commissioner. Sabi rito, the decision of the Secretary of Finance and Justice in all cases shall be final. Okay, final na. Ibig sabihin, hindi na yata maaaring iapila pa sa Korte Suprema, no? Okay, Section 176. The Insurance Commissioner must cause every company before engaging in the business of insurance to file in his office. Ito yung mga dapat na i-file ng mga gustong maging insurance company sa office ni ni Insurance Commissioner. Letter A, a certified copy of the last annual statement or a verified financial statement exhibiting the condition and affairs of such company. Letter B, if incorporated under the laws of the Philippine Islands, a copy of the articles of incorporation and bylaws and any amendments to either certified by the Chief of the Division of Archives, Patents, Copyrights, and Trademarks to be a copy of that which is filed in his office. Letter C, if incorporated under any laws other than those of the Philippine Islands, a copy of the articles of incorporation and bylaws and any amendments to either if organized or formed under any law requiring such to be filed, duly certified by the officer having the custody of the same, or if not so organized, a copy of the law, charter, or deed of settlement under which the deed of organization is made, duly certified by the proper custodian thereof or proved by affidavit to be a copy. Letter D, dami, no? Kapag hindi naman siya incorporated, a certificate setting forth the nature and character of the business, the location of the principal office, the names of the persons and of those composing the company, firm, or association, the amount of actual capital deployed or to be employed therein, and the names of all officers and persons by whom the business is or may be managed. Sabi. The certificate must be verified by the affidavit of the chief officer, secretary, agent, or manager of the company. And if there are any written articles of agreement or company, a copy thereof must accompany such certificate. Okay, papahinga lang ako. Babalik tayo maya-maya para sa Section 177 na pagkahaba-haba. Okay. Parang sinasabi niya lang yung requirements ng ng mga insurance company. Basahin na rin natin mamaya. Okay, so hindi ko namamalayan, no? 2 oras na pala tayo nagbabasa-basa dito, no? Shoutout muli kay Pernaan, no? Pernaan, ako I wish na kayo ni Cash ay maging mga abogado kayo, no? Para pagtanggol nyo ang ating bayan at ako. Ha? O sige, Section 177 ng Insurance Act pa rin. Sabi dito, the Insurance Commissioner must require as a condition precedent to the transaction of insurance business in the Philippine Islands by any foreign insurance company that such company file in his office a written power of attorney designating some person who shall be a resident of the Philippine Islands. Similar ito doon sa nakalagay. Nabasa na natin to. Mahabang mahaba siya pero nakalagay ito. Similar ito doon sa nakalagay sa Corporation Code. Okay, kung saan meron ka dapat na yung yung foreign insurance company ay meron dapat na a resident of the Philippine Islands na yun ang tatanggap ng mga summons, legal notice, etc. As if i-deliver yon sa mismong principal place of business nung foreign corporation. Kasi ang hirap nga naman nating, paano kung may kaso tayo, may hinahabol ang isang kababayan natin laban sa kanila? Paano natin nga naman sila isa-summon? Paano, di ba? Paano tayo magkakaroon ng remedyo? Okay, Section 178. No foreign insurance company shall engage in business in the Philippine Islands unless possessed of paid up unimpaired capital and reserve not less than that herein required of domestic insurance companies. So, meron kasing nakalaan para sa kanila na kumbaga parang mas malaki, no, na halaga na kailangan kapital na meron sila. And no insurance company organized or existing under the government or laws other than those of the Philippine Islands or any state of the United States shall engage in business in the Philippine Islands until it shall have deposited with the insurance commissioner for the benefit and security of its policyholders and creditors in the Philippine Islands securities satisfactorily to the insurance commissioner consisting of bonds of the U.S. or of the Philippines or of the City of Manila or municipalities in the Philippine Islands authorized by law to issue bonds or of, kumbaga meron kang, paano kayo ba ipapaliwanag? Kumbaga meron kang collateral, kumbaga, pero hindi yan ang term. Para bang meron kang pera doon na to ensure, may dineposito kang pera to ensure na kaya mong panagutan yung pagiging isang insurance company dito sa Pilipinas. Section 179, the Insurance Commissioner shall hold the securities deposited as aforesaid for the benefit and security of all the policyholders of the company depositing the same, but shall, so long as the company shall continue solvent, permit the company to collect the interest or dividends on the securities so deposited, and from time to time with his assent to withdraw any of such securities upon depositing with said commissioner, other like securities, the market value of which shall be equal to the market value of such as may be withdrawn. Section 180, every insurance company doing business in the Philippine Islands shall annually on or before the 30th day of April of each year, hindi ko lang alam kung nabago na to, render to the insurance commissioner a statement signed and sworn to by the chief officer of such company, showing in such form and detail as may be prescribed by the insurance commissioner the exact condition of its affairs on the preceding 31st day of December. Siyempre, kailangan maayos ang kalagayan ng insurance company, no? Sabi niya, provided that in case the fiscal year of an insurance company does not terminate with the 31st day of December, it shall be deemed as sufficient compliance with this section if the report is made to coincide with the regular fiscal year of the company. Okay. In such case, the report of the company shall be filed with the insurance commissioner within 4 months after the close of its fiscal year, and provided further that the insurance commissioner may, in his discretion and upon approval of the Secretary of Finance and the Secretary of Justice, grant an extension of not exceeding 3 months to any company upon his being satisfied that the period of 4 months granted by this section is inadequate with regard to said company. Sabi pa rito, immediately upon approval of the annual statements by the Insurance Commissioner, every insurance company doing business in the Philippine Islands shall publish in 2 papers of general circulation in the City of Manila, one published in English and one in the Spanish language. Wala na ito. Ganun pa rin to pero baka wala na yung Spanish language. Okay, ano na to mga insurance, ano na to? Huwag na nating basahin to. Sabi pa rin, basahin natin tong tungkol sa agents. Sabi rito, Section 189, no insurance company doing business within the Philippine Islands nor an agent thereof shall pay any commission or other compensation to any person for services in obtaining new insurance unless such person shall have first procured from the insurance commissioner a certificate of authority to act as an agent of such company hereinafter provided. Alam ko pag tinanggap ka ng isang insurance company sa ngayon 2020 ngayon, hindi mo na kailangan ng gantong authority, yung kumpanya ang nag-aasikaso nito eh. Okay? Sabi tingnan na lang natin yung mga kasi mas common ito eh, Section 190. No insurance company engaged in business in the Philippine Islands or any agent thereof shall make any contract of insurance or agreement as to policy contract other than is plainly expressed in the policy issued thereon. Nor shall any such company or agent pay or allow or offer to pay or allow as inducement to insurance any rebate of premiums payable on the policy, nor shall any particular policy holder of the same class be allowed any advantage in the dividends or other benefits to accrue thereon or any valuable consideration or inducement whatever not specified in the policy contract of insurance. So, kailangan kung ano lang nakalagay sa policy, yun lang. At hindi pwedeng, kumbaga, i-induce o akitin ng agent na kumuha ng insurance niya sa pamamagitan ng pagbibigay ng kung ano-anong mga pera or something na hindi naman bahagi ng insurance policy. Section 191, no agent, sub-agent, broker, or other person representing any insurance company shall in any way, directly or indirect, divide or offer to divide his commission or other remuneration, or give or offer to give any part of his commission or other remuneration or any other consideration as an inducement to insurance. Okay? Para maakit, para kumuha ng insurance yung tao. Pwede siguro akitin mo sa pamamagitan ng panlilibre mo ng kape, ganyan. Nor shall any such company or any agent thereof as to any new policies of insurance hereafter issued make any discrimination against any citizen of the Philippine Islands, whereby such citizen of the Philippine Islands is given less advantageous rates, dividends, or other policy conditions or privileges than are accorded to Caucasians because of his race. So baka wala na nga ito, luma na ito, pero unlawful yung magbigay ka ng advantageous rates sa iba tapos i-discriminate mo yung ibang class, yung isang class ng mga tao. Sabi rin dito, Section 192 ng Insurance Act, it shall be unlawful for any person, company or corporation in the Philippine Islands either to procure, receive, or forward applicants for insurance in or to issue or to deliver or accept policies, or for any company or companies not having been legally authorized to transact business in the Philippine Islands as provided in this chapter, and any such person, company, or corporation violating the provisions of this section shall be deemed guilty of a penal offense, and upon conviction thereof shall for each such offense be punished by a fine of 200 pesos. Iba na ito siguro, mas mataas na ito. Sabi pa rito, yung insurance commissioner may issue a certificate of authority to any regularly authorized fire or marine insurance agent of Philippine Islands, subject to revocation at any time, permitting the person named therein to procure policies of insurance on risks located in the Philippine Islands for companies not authorized to transact business in the Philippine Islands. Sa ngayon naman, na lang insurance companies na ang natin. Merong agents, yung mga insurance corporations. Speaking of insurance corporations, sabi sa Section 193, the provisions of Act numbered 1459 known as the Corporation Law and its amendments shall apply to all incorporated insurance companies now or hereafter engaged in business in the Philippine Islands insofar as they do not conflict with the provisions of this chapter. Section 194, corporations thou formed or organized to save any person or persons or other corporation harmless from loss, damage, or liability arising from any unknown or future or contingent event, or to indemnify or to compensate any person or persons or other corporation for any such loss, damage, or liability, or to guarantee the contractual obligations of or debts of others shall be known as insurance corporations for the purposes of this chapter. Sa madaling salita, pwede mong i-insure ang isang korporasyon. Domestic insurance corporations. Ito marami tayo niyan dito. Section 196, every insurance corporation hereafter formed or organized under the laws of the Philippine Islands shall, if a stock corporation, have a subscribed capital sila equal to at least 250,000 pesos, 50% of which must be paid up in cash previous to the issuance of any policy, and the residue within 12 months from the date of filing its articles of incorporation. So yung domestic insurance corporation daw ay na organized under the Philippine laws shall have, kung stock corporation siya, meron siya dapat subscribed capital equal to at least, okay, minimum requirement is 250,000 pesos, tapos 50% noon ay must be paid up in cash, okay, bago pa yung issuance ng any policy, okay, and the residue within 12 months from the date of filing its articles of incorporation. For failure to have its capital stock paid up within the time prescribed, the corporation shall not be permitted to take any new risks of any kind of character. If organized as a mutual company, in lieu of such capital stock, it must have available cash assets of at least 250,000 pesos above all liabilities for losses reported, expenses, taxes, legal reserve, and reinsurance of all outstanding risks. Any officer, official, or director of the corporation taking or authorizing the taking of any risk for the corporation in violation of the terms of this section shall be punished by imprisonment for not less than 1 year nor more than 5 years, and by a fine of not less than 1,000 nor more than 5,000 pesos. Malamang mas malaking halaga na yan ngayong 2020. Okay, saan ako? Section 196, no domestic insurance corporation shall adopt the name of any existing company transacting a similar business or any name so similar as to be calculated to mislead the public. So kung ako magtatayo ako ng isang domestic insurance company, pag sinabi mong domestic, Filipino, organized, formed and organized under the Philippine laws, di ba? Tatayo ako ng insurance, hindi ako pwedeng magtayo ng Sun Insurance kasi meron ng Sun Life Insurance. Hindi rin ako pwede magtayo ng Jollibee Insurance kasi mami-mislead na yung public dahil Jollibee is a restaurant. 'Di ba? Sikat na fast food siya. Section 1, so pag nagtayo ako, dapat ang pangalan niya ay Loloray Insurance. Section 197, no insurance corporation shall loan any of its money or deposits except upon first mortgages or deeds of trust of unencumbered improved real estate in cities and centers of population of municipalities in the Philippine Islands when the amount of such loan is not in excess of 60% of the value of such real estate, or upon the security of first mortgages or deeds of trust of actually cultivated, improved, and unencumbered agricultural lands in the Philippine Islands when the amount of such loans is not in excess of 40% of the value of such land, okay, or upon bonds or other evidence of debt of the government of the U.S. Huwag na to, government of the U.S. pa eh. Okay, section 198, no loan by any insurance corporation on the security of real estate shall be made. Okay, no loan by any insurance corporation on the security of real estate shall be made. Hindi sila pwede mag-collateral ng real estate unless the title of such real estate shall have first been registered in accordance with the Land Registration Act, or shall be a titulo real duly registered, or have been previously registered under the provisions of the mortgage law, that is, under the system of registration established by the laws in force on the date of the passage of Act number 496, entitled the Land Registration Act. Okay, madami pa ba to? Dali ah. Pusin na natin to, kayo mga hindi na masyadong mahalaga na ano. Konti na lang, hanggang 205 na lang to. Section 199, it shall be the duty of the officers of the corporation to report quarterly on the first days of January, April, July, and October. Okay. So January, February, March, every 12 divided by 3. So quarterly, January, April, July, and October of each year to the Insurance Commissioner a list. Magre-report sila ng list of such investments as made by them, and the Insurance Commissioner may, if such investments or any of them seem injudicious to him, require the sale of the same. Sabi rin dito sa Section 200, insurance corporations may purchase, hold, own, and convey real and personal property as follows. Letter A, the lot with the building thereon in which the corporation conducts and carries on its business. Pwede silang magkaroon ng house and lot o building and lot para sa kanilang conduct of business. Letter B, such property, real and personal, as may have been mortgaged, pledged, or conveyed to in good faith in trust for its benefit by reason of money loaned by it in pursuance of the regular business of the corporation, and such real or personal property as may have been purchased by it at sales under pledges, mortgage, or deeds of trust for its benefit on account of money loaned by it, and such real and personal property as may have been conveyed to it by borrowers in satisfaction and discharge of loans made by the corporation to them, provided, however, that any real estate purchased by said corporation in payment or by reason of any loan made by said corporation shall be sold by the corporation within 5 years after the title thereto has been vested in it. Letter C, bonds and other evidences of debt of the government of the U.S. or of the Philippines or of any municipality of the Philippines authorized by law to issue bonds at the reasonable market value thereof, and such other securities as may be approved by the Insurance Commissioner. So, pwede nilang hapang-hawakan yun, pwede sila mamili, they may own yung mga nabanggit na yan. Section 201, no insurance corporation shall declare any dividend except from profits remaining on hand after retaining unimpaired. So, maalala natin sa i-relate natin sa corporation code, sabi roon, ang dividendo ng mga stockholders ay binibigay ay kinukuha doon sa unrestricted retained earnings. Okay. Letter A, the entire paid up of capital. Letter B, in the case of life insurance corporations, the legal reserve fund. Meron silang legal reserve fund required by Section 183 of this Act. Letter C, in the case of corporations other than life, the legal reserve fund required by Section 183 of this Act. And letter D, a sum sufficient to pay all losses reported or in the course of settlement and all liabilities for expenses and taxes. So, magbibigay ka lang ng dividendo kapag basta hindi mo maaapektuhan yung mga nabanggit na ito. Lalo na yung mga liabilities. Ito. Section 202, sabi niya, no person, partnership, or association of persons shall engage in business of insurance in the Philippine Islands except as agent of a person or corporation authorized to do the business and insurance in the Philippine Islands unless possessed of the capital and assets required of an insurance corporation doing the same kind of business in the Philippine Islands and invested in the same manner. So, kailangan, meron kasi yan, capital requirement And meron siyang, sabi niya pa, every person, partnership, or association receiving any such certificate of authority, sabi nila, shall be subject to the insurance laws of the Philippine Islands and to the jurisdiction and supervision of the Insurance Commissioner in the same manner as if an insurance corporation authorized by the laws of the Philippine Islands to engage in the business of insurance specified in the certificate. Section 203, General Penalty. Any person who knowingly violates any provision of this chapter for which no penalty is provided shall, upon conviction, punished by a fine not exceeding 500 pesos or by imprisonment not exceeding 5 months or by both. Malamang hindi na to nakapangyayari kasi meron ng mga criminal sanctions. Baka may mga special laws na or penal laws na makita natin sa mga paglabag dito sa insurance code. And huli, sabi niya lang dito, at wala na, tapos na. Sabi na lang dito sa section 204, okay, final provisions na lang yan. Wala na siya sinasabi. So, doon po nagtatapos hanggang section 205. Okay, basahin na nga rin natin para kumpleto. Chapter 4, Chapter 6, Final Provision. Section 204, the provisions of sections 147 to 153, inclusive of Act numbered 1459, Title 8 of Book 2, Section 3rd of Title 3, Book 3 of the Code of Commerce, and all laws or parts of laws in conflict or inconsistent with this Act are hereby repealed. Section 205, this Act shall be in effect on and after the first day of July 1915. Tanda pa sa lola ko to. Lola ko 1925 eh. So again, ito Insurance Act na ito, gusto ko lang basahin ito para sa ating mga kalayman, para sa atin. Para magkaroon lang tayo ng foundation, okay? Na maunawaan natin ang contract of insurance, okay? Maaaring may mga binago na dito, may mga bago ng batas, o baka in the future may makita pa tayo na bagong komprehensibong batas tungkol sa insurance. Pero at least, meron na tayong general overview, may pundasyon na tayo ng knowledge natin sa insurance. So maraming salamat sa pagsama sa akin ngayong gabi na ito. Natapos natin ang insurance. Bago yan, mag-pray muna tayo. Glory be to the Father, and to the Son, and to the Holy Spirit. As it was in the beginning, is now, and ever shall be, world without end. Amen. Papuri sa iyo, Panginoon. In the name of the Father, the Son, and the Holy Spirit. At muli, sana po'y samahan niyo ako magbasa-basa ng mga batas. At subukan natin ipaliwanag ito in layman's term. So muli, ito si Lolo Ray. Sana may natutunan kayo. God bless and see you again.